Hello, good afternoon, everybody. I'm Wendy. This is Sinister, Truly Sinister, and it is New Year's Eve. Um, and the weather sucks here in California. So that's okay. I wasn't planning on doing anything anyway. I hope everybody had a great Christmas and you're ready to bring in the new year. I mean, it's here. I can't believe it. I don't know where the year went. Blows me away. Um, it's been a while, and I hope that you guys are tuning in for this. It's gonna be a short, video. I just wanted to update you on Aaron Spemcer. The Aaron Spencer case had some, um, motions or items dropped on the docket, and I just wanted to go over them. They're really short, they're 1 or 2 pages each, but I just wanted to keep you all posted. Also, I have some dates that might be important to some of you. The Rebecca Park case, Courtney Bartholomew and her husband Bradley Bartholomew are going to be um, in a plausible cause hearing on January 13th. And then Kimberly, Rebecca's sister, will have a plausible cause hearing on the next day, the 14th, in Wexford County. And I believe they have the option of watching their district court hearings. So hopefully we'll be able to join in on those. Then we have the Aaron Spencer case is actually supposed to start on is it the 26th? Let me see. Yeah, the 26th. So that's right around the corner. Um, I'm kind of excited, but I'm kind of nervous because I don't really have a lot of faith in Judge Elmore. She has history with controversial decisions that she's made. In fact, I have two videos um, about her and some of the decisions she's made in some of her cases, and a few of them have been overturned by the appeals court. So she's, you know, I don't know. I can't get a feeling for her. Aaron Spencer's case, however, will not be streamed. So that will just be a daily update, most likely. She's also the judge who let Wesley Hennard, a accused child rapist or minor rapist who was arrested on such charges, and I think he had a total of some ungodly number of felony charges for internet CP and the actual rape of a minor. And she let him out on bail, and he was 17 at the time. She let him out on bail, and he reoffended with another minor in a different county. And I have been trying to I found the case in Elmore's court, but none of the motions or filings are posted. They're all entered in, but none of them are available, which I find pretty suspicious, or pretty sketch anyway. I'm not sure why that is, but anyway, he is another 17-year-old, the other one being the young man from Oklahoma. who is now being sued and being taken to federal court on his grape charges. But this one was actually heard by Judge Elmore, Barbara Elmore, and she let him out on a decent, pretty low bail, I think, and he reoffended within a couple months in another county where he is now being held, and his trial for that begins in January also. I think January 29th, if I'm not mistaken. Let me see. And I don't believe this will be aired either, unfortunately. Let me see. I know I wrote it down. And then we also have the Kimberly Singler case out of Colorado. She's got a hearing on the 7th of this month. So it's going to be a busy month. I don't know if Colorado, I know they do stream their cases, but I know that there was also a situation where they quit streaming a trial this year because of a YouTuber. So I don't know if they're going to allow cameras for this one. Hopefully they do. That'll be an interesting case. I guess maybe he's not till March. I know there's a couple in March. Let me see. Anyway, I don't know if this particular court in Arkansas. Okay, he's on April 29th. So we've got a couple months before he's in court. But yeah, there's a lot of stuff going on. Rebecca Park, her biological mother, Courtney Bartholomew, and her husband. Oh, I already said that, I think. Did I? They have their plausible cause hearings in January. So it's going to be a busy month. And hopefully we'll get to stream some of them. What else? I believe that's it as far as the case and court dates go. Kelsey Fitzsimmons will start in February. So yeah, and hers will be streamed, I believe. So, but I believe Melanie Little and The Glare will be streaming her case. So I probably won't go up against the big guns, you know. Anyway, so let's get started with the Aaron Spemcer updates. The first one is the order requiring timely submission of juror questionnaires, voir dire questions, witness lists, and identification of expected family members. So I guess that's people that are going to be allowed in the courtroom, maybe? Are they not going to, is it not going to be an open hearing or an open trial? That seems a little weird. Are they only going to let's read on and see. On its own motion and pursuant to the court's inherent authority to control the conduct of trial proceedings, voir dire and courtroom admiration, The court enters the following order. Let's see. The court previously stated that juror questionnaires shall be submitted to the court by January 14th, 2026, and proposed voir dire question be submitted to the court by January 19th. That's cutting it close, isn't it? 1. The proposed questionnaires and questions shall be admitted. Sorry, let's start that one over. Number 1, the proposed questionnaires and questions shall be submitted in writing, clearly labeled and organized by subject matter. Wow, she's pretty strict, huh? The court will review, modify, approve, or reject all proposed questions in its discretion. 3, only questions approved by the court shall be asked of the potential juror. Number 4, the court may conduct voir dire itself and may limit or prohibit counsel to conduct voir dire as necessary to ensure fairness, efficiency, and compliance with the Arkansas Rules of Evidence and case law. Number 4, each party shall exchange a final witness list identifying all witnesses the party reasonably intends to call during the trial. Number 6, the witness list shall include the full name of each witness and, with all expert witnesses, a brief description of the witness's expected testimony. The parties shall follow all criminal rules of procedure and applicable rules of discovery concerning all witnesses. Said list shall be given to the court by January 12th. Absent good cause shown, no witness not disclosed in accordance with this order shall be permitted to testify. So they're not going to have any last-minute surprises, apparently. She runs a pretty strict courtroom, it sounds like. Identification of expected family members that will attend the trial in order to maintain courtroom security and to address any issues related to seating or emotional displays before the jury. Said list shall be given to the court on or before January 12th. A. This requirement is administrative only and shall not be construed as limiting the public nature of the proceeding. Okay, so it is going to be public proceedings. The information shall be solely for purposes of security coordination. Failure to comply with this order may result in exclusion of witnesses, limitation on voir dire and juror questionnaires, and other appropriate sanctions within the court's discretion. It is so ordered. She writes like a little kid. I mean, I don't know why I said that, but she really does. So that's one thing, okay? And let's move on. I told you they're all really short, so this shouldn't take long at all. This one kind of stinks, but it doesn't surprise me. This is come on. I'm using Ethernet, so it shouldn't be this slow. I don't know what's going on. Okay. This one is order admitting defendant's prior statements. On the day after reviewing the motion, having heard witnesses' testimony and arguments on admitting defendant's prior statements, the court finds 1, defendant's statements are relevant under Arkansas R Evidence 401 because they bear directly on defendant's intent, motive, and state of mind preceding the charged offense. And my only thing with that is if you're going to let his prior statements in, then Fossler's prior accusations, because he was never found guilty. They never got a chance to have a trial for his essay of Spencer's daughter. But the suspicion and the fact that he was a defendant about to go on trial for that should be allowed in. The fact that he was accused of it should be allowed in. And the fact that he has a history of that should be allowed in. If they're going to let Aaron Spencer's prior statements in, then they need to let the reason behind those prior statements in. Otherwise, they don't make any sense, right? So they have to let the background in of Fossler. They have to let Fossler's background in, because if they don't, then Aaron Spencer's prior statements make no sense at all. They don't make any sense to anybody. They only make sense to people who know what was going on with his daughter. So I don't know how they're going to do that unless they allow Fossler's prior discretions in. Okay. Sorry about that. Defendant's own statements reflecting hostility, intent, or attitude are admissible to assist the jury in determining intent. 2, the extent the statements reflect the defendant's view about resolving disputes through personal force, they are admissible for non-character purposed under whatever, including proof of motive, opportunity, intent, preparation, plan, knowledge, identity, and absence of mistake or accident. Sounds to me like she's already got her mind made up that he's guilty. That's how it seems to me. Any lapse in time between the statements and the charged offense affects the weight, not the admissibility of the evidence. Finally, under Arkansas R. Evidence 403, probative value of the statements is not substantially outweighed by the danger of unfair prejudice. The statements are the defendant's own words and are highly probative of his mental state. It is ordered, all in caps, that the defendant's statements are admitted. So, there's that. Moving right along. This one could be good, depending on how far she lets it go. Okay. Order allowing opinion and reputation of deceased. It should be and accusations. On the day after reviewing the motion, response, and hearing arguments of counsel, the court doth hold: 1, the court finds the defendant has raised self-defense. Under Arkansas Rule of Evidence 404A2, the defense may introduce reputation or opinion evidence regarding the deceased's character for violence in the community. Now, she says for violence. Does that mean S8 also? Or does that just mean violence? I don't know. Specific acts of the deceased not known to the defendant are not relevant to the defendant's state of mind. Therefore, specific acts are not allowed. So, I don't know. It's kind of sketchy. She's kind of leaving a broad opening there. It is so ordered. You know what I mean? It's kind of sounding like she's leaving herself an out for not allowing some of the stuff in or any of it maybe. I don't know. That makes me nervous. Okay. Told you this was gonna be quick. Okay. Selection of jurors. The parties and the court agree it is in the interest of the administration of justice that voir dire shall consist of a limited number of potential jurors at a time. It is so ordered. So that's um, pretty normal, I think. Um, Order denying remote testimony and requiring in person. The parties previously requested witnesses' testimony by Zoom. After consideration of the previous hearing in which Zoom was used, and after considering the nature of the proceeding, the court finds that in-person testimony is necessary to 1. Ensure the witness is not being coached or influenced. 2. Prevent exposure of extraneous information. 3. Preserve the solemnity and integrity of the judicial process. 4. The defendant's rights under the Constitution Confrontation Clause are paramount in criminal trials. It is therefore ordered all witnesses shall be physically present in the courtroom to testify. Testimony by Zoom, video conference, telephone, or other remote electronic means is denied. It is so ordered. Okay. I don't know who requested a Zoom or video witness, but she's not going to allow it. And this is the last thing. It's an order on expert witnesses. I think this is actually probably the longest one, and I think it's only 3 pages. So order on expert witnesses. The defense has given the state a list of individuals they wish to call as experts, and the state has provided a motion in limine. The court heard arguments on the issue at the omnibus hearing. The court stated then that some of the witnesses would not be allowed to testify. The court shall clarify. 1. Listed defense witnesses Jeffer, I wonder if that's supposed to be Jennifer H. Steele and Carrie J. Landau testimony will confuse the issues in this matter and would not assist the jury in this trial of homicide. Based upon the information provided to the court, Dr. J. Consulting PLLC testimony would not assist the jurors and would only confuse the issues. 3. Clint Norris may qualify as a crime scene expert. The information provided in defense response indicates he may have the sufficient training, education, and experience in crime scene analysis and or reconstruction to qualify as an expert under Arkansas Rule of Evidence 702. The proposed testimony concerns technical matters beyond the common understanding of jurors. However, no witness would be allowed to offer opinions regarding the credibility or truthfulness of any witness, including law enforcement officers. Of course not. B, state or imply that any witness, quote unquote, lied fabricated evidence, or acted in bad faith. C. Offer legal conclusions, including whether the defendant acted reasonably, lawfully, or in justification. D. Express opinions on the ultimate issue of guilt or innocence. E. And this is in bold. The above are all decisions for the jury to make. 4. The court will strictly enforce these limitations during trial. Counsel is instructed to advise the expert of these restrictions prior to testimony. Any violation may result in exclusion of the offending testimony or other appropriate relief. It is so ordered. The state's motion is denied and granted in part. The court finds that allowing the expert testimony within these parameters preserves the defendant's right to present a defense while ensuring compliance with the Arkansas Rule of Evidence. Barbara Elmore. She writes like a serial killer. So, that is it. So, what do y'all think? I think that he's got his work cut out for him. But I also think that if the jury, even if they don't hear specifics about what made Aaron Spemcer so angry enough to hunt this man down in the middle of the night looking for his daughter. I mean, other than the obvious, I mean, what's he doing with his daughter, right? But I think if they can read between the lines, basically, if she doesn't let that in, I think that they'll be able to figure it out. I think they'll know that there's an underlying situation going on which caused Aaron Spemcer to make the comments and statements that he made to Fossler's girlfriend that day and to the sheriff's deputy that responded to Aaron Spemcer's original call to report the incidents. And we just have to have faith in the system, you know? Hope that these jurors see the writing on the wall. Aaron Spemcer is an ex-military. He doesn't have any kind of criminal history. He's never been accused of being a violent person. He's never been accused or been known to take part in vigilante justice, which is what they're trying to portray him as a vigilante. And they're trying to make his prior statements show that. And I don't think they do. I think they show that he was a father that was basically in shock from what he heard was being done to his daughter. And he basically told the deputies, if you don't take care of this, he will make sure that it's taken care of. Not threatening him, but he was going to make sure that they followed through with this investigation and that they followed through with pulling Fossler in and questioning him and holding him accountable. That's how I took it. I took it to mean that he was going to hold these deputies accountable for dealing with Fossler on a legal basis, doing it the right way. But he wasn't going to be a patsy either and just sit back and let shit not progress. You know, he wanted to see some results and he wanted to see them pretty quickly. And I don't blame him. This man is in the same town as his 13-year-old daughter, and he's already violated her in multiple ways, apparently. And why am I frozen? Why take that chance that it's going to continue to happen or happen again or whatever, you know? Sorry about that. I wouldn't if it were my daughter I wouldn't. I would be on their ass every day making sure that they were following through with their investigation and that shit was being done. And I think the judge dropped the ball on that one when she let him out on bail. I don't, especially such a low bail. I mean, and with no monitoring. I mean, she said that he was to have no contact with this victim, but who was monitoring him to make sure that that was being followed? Nobody. He didn't have a GPS tracker. He didn't have to check in with anybody. He wasn't on house arrest. His movements weren't restricted, nothing. He was free to go and come and go as he pleased until his trial date. And so what did he do? He went right back at it with Aaron Spencer's daughter. What kind of, I mean, obviously he wasn't the type of guy to learn from his past behavior. The fact that he got caught once didn't inhibit him from continuing his contact with her. He came out and he went right back at it. He wasn't in the least bit intimidated by Aaron Spemcer. He wasn't the least bit affected by the fact that he was going to be standing trial very soon for his transgressions. He wasn't the least bit put off by any of it. He just took the fact that he was out on bail as another chance at offending with this young lady. And it's horrific. It's like Judge Elmore dropped the ball. That's all I can say. And I think she dropped the ball on Wesley Hennard, the 17-year-old who reoffended while he was out on bail, because he also had no restrictions put upon him. He had no GPS. Didn't have to check in with anybody. He wasn't on house arrest. No restrictions at all. And what did he do? He reoffended within a couple months. I think Fossler reoffended sooner than that. So if anybody learns from their mistakes, it's Judge Elmore, but I'm not hopeful. I mean, I hope she proves me wrong, but it sounds to me like she's already got her mind made up that Aaron Spemcer was going for vigilante justice. And because if he wasn't, and if he was acting in defense of his daughter and himself at the time, then that makes Elmore's decision to let him out on bail that much worse. And that's something that she would have to face and take accountability for. And I don't see her as the type of person to do that. From what I've read about her, I just don't see her taking accountability for fucking up, to put it bluntly. So, and the only way that she doesn't have to take accountability for fucking up by letting him out on bail is by the prosecution proving that Aaron Spemcer distributed vigilante justice. It takes the attention off her and her mistake. And I just hope I hope she can sleep good at night, because she fucked up. That's all I have to say about it. That's my opinion. I don't know her personally. I only know what I've read about her, but yeah. So anyway, I hope that you found this interesting, and it sounds like those were the last minute instructions from the court before the trial starts, because we're not able to see any of the pre-trial motions or pre-trial hearings. So even if they did have one or two right before the trial starts, we wouldn't be able to see him or watch him. We would only be able to hear about him in the news. So, but if I do hear about any more, I will definitely get back to you. There was one more case I wanted to mention, and that was Jacqueline Garcia Torres, also known as Mimi, from Connecticut, the 11-year-old whose mother and boyfriend and aunt are all being charged with her murder by starving her to death. And there's also a multi-million-dollar lawsuit being brought against the Children and Family Services of Connecticut because it took them so long to realize that she was even gone. She was missing, so to speak. Months, almost a year, I think, before they realized that they lost track of this little girl. So badly that Jacqueline's mother had one of her sisters pose as Jacqueline on a video call with child services. And they believed it was Jacqueline. That's how little they knew about Jacqueline. They didn't even recognize that it wasn't her. So disgusting. Simply disgusting. And I know that the caseworkers for family services, children and family services, are very overworked and have a huge caseload, but that is no excuse for not knowing for a year that a little girl is missing and dead in a bin at a vacant house. There are no words for that. And I don't care how busy or how big of a workload you have, that shouldn't happen on your watch. Ever. It just shouldn't. So there's that. They have another hearing in January, and I'm not sure if that will be televised. Because the last hearing they showed still shots. So it looks like there was a video or a camera in the courtroom. So I'm going to have to dig into that a little more because I really would like to watch those because I think those animals need to be held accountable, and I'm there for it. She was a beautiful little girl. She had her whole life ahead of her, and these monsters deprived her of that, and they deprived the world of this bright young girl who was ambitious and ready to take everything on that she could, and the world will never get a chance to know her or see what she turns out to be. And no child should ever be cheated of that. So I would love to watch those monsters go. I would love to watch their trial. At least the mothers, because to me, it doesn't happen without her being compliant and being the ringleader, I would think, because she's the mother, and no one can touch a mother's child if the mother really doesn't want them to. No one can mistreat your child if you don't really want them to, because we all know how mama bears can be, right? So, and to be pregnant during all of this and not have it, and it doesn't affect you. You're with child, so your hormones are raging. You should be going through those nesting phases, and she allowed her 11-year-old child to starve to death while she was pregnant with another baby. I don't get it. I don't even pretend to understand how a mother can do that, whether she's pregnant or not, but definitely just evil. Pure evil. And we're seeing too many of those types of cases these days. And I don't know if it's just because there's more of these cases, or is it that we are able to read about them and find out about them because of the internet? Is that it? Have we always had this many cases like this, and we just didn't know about it because we didn't get newspapers from every state or every city? Maybe. It might be the fact that the internet is bounding, and so we're able to follow cases throughout the world, but either either way, it's horrendous, and we need to put a stop to it. It needs to stop. These young kids are being taken for no reason at all, just because the parents get tired of parenting, apparently. I mean, give them up for adoption or something. There are plenty of people out there that would love to have these children. Anyway, so I will say goodbye, and the next time I see you, it will be 2026. I hope everybody is safe for the new year, and yeah, until then, take care, keep warm, stay dry, stay safe, and I will see you in 2026. Bye-bye.